Donald Trump is overhauling his legal team amid growing calls to unseal the federal indictment against him before Tuesday's arraignment in Miami. Joining us now is former federal prosecutor and a member of Donald Trump's legal team during his first impeachment, attorney Robert Ray. And also back with us is Andrew Weissmann. Robert, it's really good to have you back. I really enjoyed our conversation the other day. I want to ask you, since you know what it's like to defend Donald Trump in a legal sense, what do you think of Jim Trusty and John Rowley resigning? Or maybe being fired? What's your sense of it?
I think the news seems to be that would be somewhat unprecedented. It's not unusual. I think Andrew spoke to this. You know, a lawyer gets hired to do a job. That job was prevent me from being indicted. Once that happens, separate and apart from the Mr. Green problem, once that happens, it is not unusual to switch legal teams to go with a trial team that's going to defend him actually in a proceeding that is post-indictment. So it is actually a natural breaking off point. I don't consider that to be unprecedented at all. It might be a little unusual, but it's a fairly common occurrence that the team that gets you to the pre-indictment stage, if they are unsuccessful, a new group of lawyers come in.
This is a really big charge.
By the way, I know Todd Blanche very well.
Is he capable of doing this alone? Or does he need some help from some South Florida lawyers?
He's first rate. He is a trial lawyer. He's also a friend. It would be, I think, expected, and I think the former president has already signaled this, that he's bringing in other lawyers, and I would expect to have talent, which is to say trial lawyers, who are experienced in practicing before the Southern District of Florida. And that will happen. I can almost guarantee that will happen. So that will be the trial team. It'll be Todd and it will be other people, criminal defense lawyers who have experience in the Southern District of Florida.
When it comes to the audio that CNN has and the Washington Post and the New York Times that has Donald Trump saying on tape that he's got a document in front of him, it's classified, and I could have classified it while I was in the White House. I can't classify it now. The New York Times is reporting that somebody else in the room, a woman, responded by saying, now we have a problem. How do you see any wiggle room out of that?
Well, the other piece you played, I guess the thought occurred to me about wiggle room. You know, I understand that everybody seems to think it's sort of an axiom that in a post-Watergate environment, these laws that supposedly apply to the president are binding on him with regard to how to handle presidential records and whether material is classified and whether the president has unilateral authority to declassify. A lot of the law that we're talking about, post-Watergate developments, none of that stuff has been tested vis-a-vis a former president of the United States who was the president of the United States when he had the authority to do things. So I would not be surprised. I don't know the answer to the question is the short answer. But there's going to be, I can guarantee you, there's going to be pretrial motions that get to the question about whether or not the president had authority. And more importantly, the Justice Department has to prove and take the position that he doesn't have the authority, which is a very awkward position for the Justice Department to be in. They are typically the guardians of presidential prerogative and power.
But aren't there procedures, and let me bring Andrew in here, who worked in the government. There are procedures for declassification in and out of any SCIF.
Well, there are procedures. The question is whether constitutionally they can be imposed on the President of the United States. I'm not so sure about that.
Do these things need to be settled now?
So I do think that it's fair to say that there will be an effort to say there are novel legal issues because you're dealing with somebody who is the former president. There may be a time period where they're focusing on when he was the president. I don't really see how that deals with the obstruction count. I mean, one of the things that may be very strong here is that you make all sorts of arguments that are arcane and that maybe they'll pass muster. But there was a grand jury subpoena that requires documents to be returned. That clearly was served on the former president. He
I agree.
Had to return them. I just don't know. I don't. My question to you, and again, it's reading from the outside, so it's hard. But what's the defense to that?
I don't know until I see, until we see the indictment. Maybe we'll see it today. I'm guessing there's going to be a pretty big push.
What's your expectation? How high is the hill that, based on what we know just now, that the defense has to climb?
Well, it bumps up against, though, remember, a criminal prosecution. A lot of these things are relatively speaking, undecided, and we can all usually live with ambiguity. The problem is the Justice Department has to prove essentially the negative. And that's not easy to do. The Justice Department is going to have to prove the president doesn't have that authority. And it's going to have to be clear that that was the case and that the president knew that he didn't have that authority. And I listened to the clip. Katie, that you just played, and it's the president's on tape basically saying, in addition to the part that you referenced me to, he's on tape basically saying, you know, I'm the president and I get to decide, and there's a procedure. But it's not clear that I necessarily have to follow
The
it.
Espionage Act, excuse me just a second. The
sorry,
Espionage Act precedes the Nixon eras. It goes back to, I believe, 2017, or rather 1917, the Espionage Act.
Right.
And it just has to be defense information, not classification. So classification may not even be relevant.
Well, maybe, but on the other hand, remember, all of this information is running around Donald Trump's head. You're talking about documents. You're not going to be able to lift the stuff out of his head. What can he and can't he talk about? I mean, I don't know. I think there's some real problems about trying to say you're going to prosecute somebody under the Espionage Act with regard to the disclosure of information. Now, having said all that, I do agree with those who have said a little bit of the wait and see thing. If there's really harm to the United States, I don't know what the prosecution has, and I don't know what the trial is going to look like, and I don't know what the classified information is. But if there's truly harm to the United States, that's another case. And, you know, that's a serious matter. It's already serious. Why is this serious? More serious than the New York District Attorney's case? This is a case where if he's convicted, he could go to jail. That's why it's serious.
For a long time.
You know, felony and whatever, blah, 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 blah. It's a case where jail time is in play.